This is The Synthetic Lens. I'm David Carver. It is Wednesday, May 20th, and the Musk versus OpenAI case has moved from the verdict to the appeal gate. One sentence of context because we have already covered the trial. On Monday, Musk lost the trial-level fight after an advisory jury found key claims too late and Judge Yvonne Gonzalez-Rogers accepted that result. The new development tonight is not another recap of that verdict. It is a fresh court filing about what happens next. The public docket now shows Document 578, OpenAI's response on Federal Rules of Civil Procedure 52A and 54B, and Document 579, Microsoft's Joinder. We captured both through CourtListener's recap storage after the 5 p.m. Pacific sweep.
And those rule numbers matter because they tell you where the fight is going. Rule 52 is about findings and conclusions in a bench trial posture. Rule 54B is about whether a court can enter judgment on fewer than all claims and let an immediate appeal go forward before the whole case is done. Musk's side wants the path open for a faster appeal on the claims that just failed. OpenAI is saying, not so fast.
Which is very different from the public version of the story. Outside the courthouse, the headline is, Musk says he will appeal. Inside the docket, the narrower question is whether he gets a shortcut now or whether he has to wait until the remaining Phase 2 claims are resolved.
Let's start with what OpenAI concedes. In Document 578, the OpenAI defendants say they agree with Musk that, quote, the court's existing findings and conclusions are sufficient to comply with Rule 52's requirements. They also say they do not believe the court needs to add a statement that its ruling is based on the same legal standards reflected in the advisory jury instructions, but they have no objection if the court does so.
That is the least dramatic part, but legally important. OpenAI is not trying to create ambiguity around the court's findings. It is telling the judge, the record is enough.
Then comes the fight. OpenAI opposes Musk's request for Rule 54B certification. Its argument is that Rule 54B judgments are disfavored, reserved for unusual cases, and require a seriously important reason for a piecemeal appeal. OpenAI says Musk has not offered one.
In plain English, OpenAI is arguing that Musk chose to bring a large multi-claim lawsuit and now should not get to split off one piece for immediate appeal just because that first piece went badly.
Exactly. Document 578 says Musk joined 26 causes of action into a single complaint. OpenAI's position is that he should pursue appeal in the ordinary course, after final judgment on all claims.
That phrase, final judgment on all claims, is the center of tonight's episode. There is no final judgment in the public record from this run. There is no notice of appeal. There is no Ninth Circuit docket. There is no public May 18th transcript. What we have is a fight over whether the district court should certify a partial judgment now.
And OpenAI says no, partly because the remaining Phase 2 claims are not cleanly separate. In Doc 578, OpenAI points to allegations in the second amended complaint that overlap with facts from the completed trial, including allegations about transferring OpenAI assets to for-profit entities and soliciting contributions under allegedly false pretenses. OpenAI's argument is that if the Ninth Circuit hears one appeal now and another later, the appeals court may have to revisit the same facts twice.
That is where this stops being procedural trivia. Musk's public framing is that the real OpenAI mission question remains untested. Bloomberg Law's May 20th headline says the fight heads to appeal with core claims untested. OpenAI's filing is a direct response to that posture. It says the appeal should not jump ahead while overlapping claims still sit in the district court.
The filing also points to pending motions to dismiss the Phase 2 claims. OpenAI says those motions are already fully briefed and, if granted, could promptly dispose of the remaining claims. The cited docket numbers for OpenAI's motions are 103, 128, and 150.
Microsoft adds a small but useful clarification in Document 579. Microsoft joins and adopts OpenAI's response and notes that its own pending motion to dismiss the Phase 2 claims is at docket 102, with a reply at docket 148 and a supplemental reply at docket 159 regarding D. Templeton and Reid Hoffman's status as defendants.
So Microsoft is not just standing nearby. It is aligned with OpenAI on the procedural posture: finish Phase 2 or resolve it first, then appeal in the normal sequence.
There is also a sharper passage in OpenAI's brief. OpenAI argues that an immediate Rule 54B appeal would give Musk every incentive to delay prompt resolution of the Phase 2 claims. It also says delay risks harm to the administration of justice because, in OpenAI's words, Musk has continued to publicly impugn the integrity of the proceedings and attack OpenAI and its principles.
We should be careful there. That is OpenAI's argument, not a new finding by the judge. The brief cites a Deadline article about Musk's post-verdict comments and cites an earlier docket filing about an alleged threat to make Brockman and Altman the most hated men in America.
Careful distinction noted. The court has not ruled on OpenAI's Rule 54B opposition at production time.
The bigger picture is that OpenAI's trial win did not end the whole case. It ended the Phase 1 claims at the trial level. The company is now trying to prevent that Phase 1 outcome from becoming an immediate appellate detour while the rest of the case remains pending.
And Musk's side, judging from the Rule 54B request that OpenAI is responding to, wants the opposite: make the dismissal appealable now.
What should listeners watch for next?
First, a court ruling on Rule 54B. If Judge Gonzalez-Rogers denies certification, Musk may still appeal later, but the immediate route becomes harder. If she grants it, the Ninth Circuit path opens sooner for the Phase 1 result. Second, final judgment. We did not find one tonight. Third, a notice of appeal. We did not find one tonight. Fourth, the May 18th transcript. There is a transcript order on the docket, but no public transcript in this run. And fifth, Phase 2. The pending motions to dismiss may decide how much of the remaining case survives.
For OpenAI's business story, this is not as clean as case over. It is more like the biggest trial-level threat has been contained, and now the company is trying to keep the appeal from interrupting cleanup. That matters if the reporting about IPO preparation is right. But the court document itself is procedural.
That is the clean read tonight. No new verdict, no filed appeal, no final judgment. But there are new court documents, and they tell us the post-verdict fight has narrowed to timing again. Musk lost because the court accepted a timing defense. Now OpenAI is fighting the timing of his appeal. For the Synthetic Lens, I'm David Carver. Marcus Chen, Stan Rogers, thank you. We'll keep watching for the Rule 54B ruling, the final judgment, the May 18th transcript, and any notice of appeal.